The attack is completely off base for a number of reasons. Remember, Justice Alito, during his hearings, touted his background as helping him. Everybody has a background that they bring into the deliberative process. And a wide range of backgrounds, I think, helps the deliberative process reach a better result. There's a reason there's more than one judge or justice on the United States Supreme Court. It's the idea to get the views of many, integrated discussion, and having people with various backgrounds helps that. With respect to Judge Sotomayor, a distinguished full ride at Princeton, one of the top students graduating Princeton, a graduate of Yale Law School, 17 years on the bench, one of the most cited law professors, one of the most cited judges on the Court of Appeals. She's clearly one of the supreme legal minds in the country, and to suggest that there's anything else other than her extreme qualifications that are wonderful qualifications that qualify for this is just nonsense.
Okay. And what about diversity as well, too?
And she brings a great perspective to the court. I mean, the fact that she grew up in a single-family home under adverse circumstances, I think really will enrich the deliberations of the body.
And Judge Sotomayor has suggested that, her life experiences indeed have helped inform her as a judge. What's wrong with that? Isn't that something we should be kind of hoping for?
In Minnesota Republican Party versus White, Justice Scalia said that judges come to the bench with their own views. It's a fact of life. It's a fact of life. Some do it with Federalist kinds of views. Some do it with other kinds of views. When they get on the bench, the obligation of the judge is to not let those decisions guide a particular result. But at the same time, that judge can fully and should bring that experience to bear so that the decision that the court eventually comes up with is better because it's been better thought through. Well, let me be clear first about originalism. The conservatives on the court use originalism consistently and completely except when they don't. And there are a lot of instances where they don't. They abandon it completely in their discussion of affirmative action. It turns out that their brand of originalism looks a lot like the originalism that Tom DeLay might have used if he had been a framer. It's a very politically driven kind of one that is result-oriented. It's also, if we took originalism seriously and what it's designed to achieve, I'm not sure it's consistent with what the original framers would have wanted. They used broad principles for a reason. They understood that terms like due process could have different meanings in different contexts. I think what was presented during this conference in the book by Pam Carlin, Goodwin Liu, and Chris Schrader is a suggestion that faith to the Constitution doesn't mean a literal reenactment of what James Madison would have thought. It's to taking the essential constitutional principles that are embedded in that doctrine and applying it to the issues at hand. And that really is originalism, a true kind of originalism, because it works with the original founding principles of the document to create a jurisprudence. I hope that Judge Sotomayor looks at that kind of method of interpretation.